Terrific. Well, good afternoon. My name is Nathan Stelter. I'm the president here at the Stelter Company, and excited for you to join us today for our webinar with our good friend, longtime friend Johni Hays, on how to eliminate delays obtaining IRA death proceeds. I'll introduce Johni in a quick minute here, but before I do, just want to say a couple words about the series. Many of you are familiar. Stelter offers this webinar series free of charge throughout the year, and as an industry leader, we're committed to continuing to provide resources and tools like this to, I'm a big believer in as the tide rises, so do all boats in the harbor. For free, just for the entire industry. This actually has been a crazy busy year. As most of you are probably aware, you've been included in a lot of webinars and a lot of Zoom calls. I think this is actually our 12th official webinar of the year, and we've covered a variety of topics, all of which can be found on stelter.com/webinars around deaths, legacy challenges, and now IRA proceeds. This is our last and final presentation webinar of the year of 2020. We're excited to share that we've already got our first speaker for 2021 lined up, and Russell James will actually be kicking off our 2021 calendar in January. He'll be sharing insights into raising major gifts in the aftermath of COVID-19. So be sure to go to stelter.com/webinars to register for that. Now back to today, to our good friend Johni Hays here. Johni comes to us with more than 27 years of experience as a practicing attorney in charitable and estate planning. Johni's, hopefully you've heard of Johni and heard her speak. She's terrific, but she's a recognized leader in the subject of charitable gift planning and has served as president of the Charitable Estate Planning Institute. Has also authored the book Essentials of Annuities and co-authored 2 books, The Tools and Techniques of Charitable Planning and Message from the Masters, Our Best Donor Stories That Make a Difference. Johni serves on the Smithsonian's Professional Advisors Network in Washington, D.C. And this year, I was on the call and at the conference, Johni received the Distinguished Service Award from the National Association of Charitable Gift Planners, of which she's part of the Leadership Institute. She serves on the editorial advisory board for the books Tax Facts on Investments and Tax Facts on Insurance and Employee Benefits, and is a founding charitable planning author of Steve Lambert's electronic newsletter, LISI. Johni's been engaged in practice of law, with emphasis in charitable estate planning since 1993, and prior to joining the good folks at Eddie Thompson and Thompson Associates, Johni was on staff as a senior gift planning consultant for us at the Stelter Company. So it's always awesome to bring Johni back, and I will turn it over to you.
Thank you so much, Nathan and Jen, and all of my good friends at the Stelter family. I'm really tickled and honored to be here with you today. So thank you for that. So what we want to talk about today is how to eliminate delays obtaining IRA death proceeds. It's a very popular topic for all nonprofits as donors leave parts of their IRAs or all of their IRA to nonprofits as a charitable gift upon their death. Then how can you, the nonprofit organization, obtain those IRA proceeds efficiently and quickly from the IRA custodian? So today's presentation is going to describe what type of problems many organizations are having in getting those death claims paid, who's doing it, what's happening, when does this happen, and why. Steps you can take today in your own office to help your nonprofit. And then I also want to share with you national work that's being done towards a permanent solution to this situation. So that's where we're headed. Let's take off. So the who, the what, and the when. What's been happening for the last few years now is charitable organizations have been experiencing delays and are being sent what I call a draconian amount of paperwork from some of these IRA institutions when the charity is trying to get an IRA death claim paid to them. It's just been an enormous hassle. What's really happened is some, and not all, of these IRA institutions have instituted new procedures for the charity to make the claim. So in the old days, when your donor left your organization as a beneficiary of their IRA, after the donor passed, you certainly just needed a death certificate and maybe a single-page form from that IRA custodian in order to apply for the death benefits, and you would get a check within 30 days. But now, instead of paying a death claim on that original donor's IRA, some of these financial institutions are requiring you, the nonprofit, to actually apply for and open up a new account at that same institution. And what they're doing is, behind the scenes, they're going to transfer the money from your donor's IRA over to this new account that they've made you set up. Well, you really want paid on the original claim, the original IRA, and we'll get to that in a second. But they want you to open up this new account. The new account can be called several different terms. We call it an inherited IRA. Some institutions call it a beneficiary IRA. In the old days, we used to call it a stretch IRA because the beneficiary could stretch out receipt of the proceeds over their life expectancy. But we're charitable organizations. We don't have life expectancies. We have no intentions of stretching out our death claim, our benefits, because we want them in our missions to do the good work that we do right away. In order to establish this new account that they're forcing you to open up, what they're saying is, the IRA custodian is saying that now you, the charity, have become their new customer. Well, what difference does that make? Well, it makes a legal difference, because if you are a new customer, then they have to follow the Patriot Act rules, some know your customer rules, some things that were developed some years ago to help stop the spread of terrorism and funneling money to terrorists. And I know that sounds like it doesn't apply, but I will explain how they're making that apply. So the Patriot Act now comes into play when you're forced to open up a new account. What does that entail? Well, for them to go through the due diligence of you being a new customer, they're going to do things like they are going to require that they go through and find out the personal social security number of certain staff members. So it might be your CFO, it might be all your board members, it might be your executive director. Well, remember, that executive director, that employee, is not the recipient of the death claim. It's your entity, whether you're in a corporate form or a trust-based charitable formation. It's not the individuals, and you know that your organization has its own tax ID number. So why in the world would we be giving our personal social security numbers out to these organizations that are often subject to identity theft and all kinds of things, losing all our data breaches, and having your personal social security number end up going to some foreign country. In addition to the social security number, they're asking for other personal information. So we've seen situations where they've asked for the personal financial statements of the CFO, personal statements, or of the board members, home addresses, copies of driver's license, things that aren't really making sense. And don't they know that the charity is the beneficiary and the charity has its own tax identification number? So this isn't really making sense. I've done a little graphic here. So the green box you see in front of you is the donor's IRA, in which they've named you as the beneficiary. You want paid on the green box. But what they're doing is they're requiring you to open up a new account, which is the blue box, and behind the scenes, they're transferring the money from the original donor's IRA, or the green box, over to the blue box, and they're saying you can only surrender the blue box. Well, that's where we're saying you don't want to go there, because that's when the Patriot Act and all these other acts they say come into play. So you don't want to go to the blue box. You want to hold your feet firm and say you want paid on the original green box. Now, why the Patriot Act? We talked about it was a way to prevent terrorism after 9/11, and that's a good thing. We all know that. But sometimes these laws get applied to, let me just call, a stupid situation. Because is your nonprofit a known terrorist? I'm in Iowa right now. I can guarantee you Iowa State University Foundation, University of Northern Iowa, University of Iowa Foundation, and all our many other institutions in Iowa are not terrorists, okay? The Smithsonian Society, they are not terrorists. St. Jude's, they are not terrorist organizations. So it doesn't really make sense that they're having us go through these hoops to do that. Now, not only the Patriot Act, but some IRA custodians are also calling it a know your customer rule, customer due diligence, bank secrecy, all that kind of stuff. It's all the same thing that they're saying applies. Well, does it really apply? So I went to the federal government agency that oversees the implementation and the compliance of the Patriot Act. And so I wrote to them and I gave them a situation. If a charity is the beneficiary of an IRA, are they considered a new customer? And here's what they've actually said to me in writing. If the beneficiary, and that's you, the nonprofit, if you continue to maintain the account after the passing of the donor, then the bank can treat you as a new customer. But I know that all of you are not wanting to be a new customer. You don't want to leave your money there, and the entire time you're asking just to get paid on the original account, and there's no way you want to maintain that account. So in other words, this could be the smoking gun. We need to assert ourselves against these institutions for all this draconian paperwork that they're asking us for. Now, just as a reminder, you want paid on the green box. You don't want paid on that new account. I just spoke with a woman yesterday on the phone on behalf of a charitable organization, and she said that they sent enough paperwork to keep her busy for 15 years. And in that paperwork, they never really said to her that you're opening up a new account. And so she did open up that new account on behalf of the charity. She did give them her own personal Social Security number. She just didn't realize that that is what is happening in this maze of paperwork. Now, what they'll tell you sometimes is, gee, our computer systems won't allow us to do that. We can't generate a 1099-R on that original green account. So what do we say? And I'm going to give you here in a few minutes sample letters that you can write to assert yourself against having to do this. But what we say is, you know what? If your computer systems can't pay the claim, then go ahead and pay it manually. We know you can, and you can issue us a manually generated 1099-R. Now, what is that? That's the paperwork that the IRA custodian submits to the IRS to say that they paid a taxable account. Well, fine, send us that manually generated 1099-R because we're a tax exempt organization and our tax rate is 0. I want to stop for a second, and I want you to know that pushing back is your own prerogative. If you as an organization are comfortable sending in the personal data of your staff, of your executive director or your CFO, go ahead and do that. I'm not telling you you can't. I'm saying if you want to push back, we're showing you how you can push back successfully. But let's say you're a smaller organization and you have a very large death claim, and you're not in a situation where you want to be able to push back. If you want to provide that information, go ahead and do that. It is your choice. Why is this happening? Why? Well, we've talked to you about the Patriot Act, and what we have said subliminally is that Their computer systems are just saying everybody has to open up this second account, regardless of if it makes sense for a charitable organization. Because why would any charity want to leave their money at that IRA custodian over 10 years or whatever it is? Of course not. We want the money for our great missions and to serve the people that we're helping. So we think that these IRA custodians maybe never assumed or never took a look at the fact that charities are also beneficiaries. What they're trying to do is asset conservation. We know that the IRA custodians make more money the longer they have the money on hand at their institution. So they have likely set up these rules so that they are keeping the money in-house a bit longer. And what we're saying is we're not that group of customers that want our money there longer. Listen to some of the things that they have told me over the last few years. I've certainly had pushback from them because, as you know, when we push back, sometimes they're going to push back. And so what they've said is, our computer system won't allow us to do what you need it to do, Johni. And we've already talked about that. They can manually process the death claim if they want. And because of that, we cannot work with typically and get the answers we need with the entry-level people that answer the telephone. This is a situation where we're going to the top of these IRA custodians and we're going to the general counsel's office to ask for what we need. When we get a little bit farther and we talk about the letters and the sample letters that we have, you will see why we need to talk up to the general counsel letter. Because, again, the entry-level people, or particularly the agent you're working with or your local office, they are not going to have the authority we need to ask them to manually generate our claim. So we talked about, yeah, they can't do the 1099, and we know that they can do it manually. And then I've heard them say, you know what, Johni, everybody does it this way. Well, no, that's not true. In fact, we're going to show you a listing of what IRA institutions are allowing us to have our death benefits paid right away and which ones are requiring the inherited IRA. So it's all over the board. Every financial institution has their own set of rules. And so I'm going to show you where we've made a database and we've made that easy for you to be able to figure out what paperwork you need depending on who the IRA custodian is. I've also heard them say we'll never make an exception. We never will. Well, sure, when you talk to somebody at the entry level or the mid management level, they don't have the authority to make that exception. And so they very well may say we can't make an exception. That's why we're going to the top where the authority is. And then I had somebody say this to me one time. He said, Johni, if your nonprofit would just do as we say, you'd get your money faster than if you complained. And I can guarantee you that's not the truth. Well, there are other things they've told us. Well, I had one nonprofit that was told by their IRA custodian that they wouldn't even tell them the dollar amount of their death claim. They wouldn't even tell them what they were legally entitled to, what the dollar amount was. And so the nonprofit was trying to decide if they had the resources to fill out all this paperwork and make this claim. They needed to make a good decision. How much was it? And so this nonprofit has told me that this is not teasing and not exaggerating. When they ended up getting their share, it was less than $1. In fact, it was about 10 cents. Now, if you had known ahead of time that your share was going to be 10 cents, would you have bothered the paperwork and the staff time with it? Of course you weren't. You wouldn't have done that. So it's getting crazy out there. Some have said we aren't going to compromise, and some of them get a little nastier. We've heard them say, let the death claim sit with us, the IRA custodian, until it goes to a statewide unclaimed property, and then try to get your money. Or go see a judge and get a court order if you don't like what we're doing. And in some ways, the problem, we're making great progress, and I'll tell you about that. But in other areas, things are getting worse because some IRA custodians won't even tell the charity that they are a beneficiary in the first place. As you know, with planned gifts, not every donor will come forward and tell us if we are a beneficiary, right? We know 2 out of 3 people won't tell us that they've left us in their estate plans. And so some IRA donors haven't told us, the nonprofit, that we're a beneficiary. So if we don't know that we were a beneficiary, and now the IRA custodians won't tell us, then we're in a really serious pickle. And I know this because one of these IRA custodians actually says it on their beneficiary form. They actually say, we will not tell your beneficiaries after you die that they're entitled to this. It's just an unbelievable lack of service. So you might be thinking, well, what can our organization do today? Johni, you've told me about the problem. Now I'm aware of the problem, but we're a nonprofit. What can we do today? I need to reiterate as much as possible that the communication is best if it comes from the general counsel of your organization to the general counsel at the IRA custodian. If you talk to the local advisor at the IRA custodian, the agent, the manager, they may not have the authority to make the exception that you need. They may not have it. And so that's why Jonathan Tidd, who's been working hard on this as well, he says we've got to communicate with the general counsel. Luckily, we have a database freely available to you that has the general counsel's name and address at all these financial institutions. We'll get to that database in just a minute. Well, what should your letter say? If you are the beneficiary and they've sent you a packet that's this thick of letters, how do you assert back and say that's not the path that we want to take? We have sample letters for you. Nationwide, we have been working on a permanent solution to this problem, but for now, we have a database that is available to each and every one of you on this call today. In fact, it's available to all nonprofits that need this information free of charge across the United States. I'll show you how to get to this database, but let me tell you what's in it. For each IRA custodian, we'll list the name of the general counsel, we'll have a sample letter there, we'll have some attachments, and we'll tell you what their process is. If there are more letters that need to, or excuse me, more attachments, we're going to tell you that. So that's on an IRA by custodian basis. So sample letters, it is available on the National Association of Charitable Gift Planners website. So they are giving all of you this information that we collect. And it's been collected by the RIFT project. And RIFT stands for Release IRA Funds Timely. So the RIFT project's put all this together, and NCGP has made it available to all of you. Free access. You don't need to be a member of your local, and you don't need to be a member of the national CGP. There on the screen is the web address to access that. Once you access that, you want to go to the Advocate button. So you're going to see that in the middle. You're going to click on Advocate. Once you're there, you're going to see some great articles. And these are important if you would like information, your staff would like, your development officers, your plan giving, your major giving, your annual fundraising staff, that they can read to get a summary of what the situation is like and why it is going on. So there's different articles there by people in the industry. Those are also articles that you should share with your business office if they are the ones that are trying to collect the IRA proceeds, your general counsel's office if you need them to write a letter or to make a call on your behalf. So those are articles that you need to share. In fact, just this morning, a law firm called and they wanted that information. The RIF database then on the website, as you can see on your screen, it is organized by the different custodians. So Ameriprise, we've got BNY Mellon, we've got Charles Schwab, and they go all the way down there. In fact, I've never really counted just how many IRA custodians are on there. But once you click on the particular IRA custodian that you're working with, you're going to see, okay, here's what Wells Fargo says. And so there'll be a rundown on whether or not they do require an inherited IRA or if they will pay it without having an IRA. And a lot of times we put who is the best contact person. It might not be the general counsel if you don't need a letter, but who's the actual person in the company that's processing those death claims. Oops. So here's, for example, Morgan Stanley. They don't require an inherited IRA, but here are the couple of the forms that they require. So you can just click there and actually get the forms that they require. They've got an affidavit of domicile form and an IRA distribution form. Like it says, they don't need a corporate resolution and it takes about 10 days. And so that's what you do with Morgan Stanley. And then there's Northern Trust. So we've tried to make it easy for all of you. These are the IRA custodians that as of 11/30, these custodians do not even require an inherited IRA. So these ones should be the simple, straightforward ones. And if that's not the case with your experience, then you let me know. And I will step in on a pro bono basis and see what's going on and straighten out the people at these IRA custodians for you. And that's what the RIF project does, again, on a pro bono basis. So we've got BNY Mellon, Merrill Lynch, Morgan Stanley, Raymond James, TD Ameritrade, US Bank, Wells Fargo. These don't require an inherited IRA. So they're going to be the easiest ones for you to get your proceeds back very, very quickly. And we are grateful to those IRA institutions for working kindly with charities and not making it difficult. Now, 3 organizations, institutions, we actually have to ask for an exception for. We have to ask them for an exception against their general rules, and that's Schwab, and that's Edward Jones, and that's Vanguard. And so on the database, under those, we have the specific letter to ask for the exception. And so you're going to find that letter in there. In fact, Charles Schultz of Crescendo has been very helpful in writing these letters. And so you're going to see in the database this sample letter. Again, it's going to go to the general counsel, but everything you need is there. Now, in another way, this problem can be getting worse. And so what we're trying to do is nip it in the bud now and get the attention of the federal government so that we can stop some of these practices. What we're finding out is some of these big financial institutions are requiring a second account to be opened for non-IRA accounts. Well, what does that mean? So after tax money, sometimes the financial institution will call it a TOD account because the IRA owner did a TOD, which is transfer on death, which is similar to a beneficiary form for this savings account, for example, that they have at Morgan Stanley. Okay, so somebody set up this after-tax account, Morgan Stanley TOD, and they've named your institution as the TOD beneficiary. Well, now what we're finding out is some of these custodians, not all, are requiring that you, the charitable organization, have to open up a new account, go through the whole Patriot Act, know your customer, bank secrecy stuff, and then liquidate that second account. And they also do that to individual beneficiaries as well as charities. And what we found out lately is some of those great custodians on the prior page that don't require an inherited IRA for charities are actually requiring the second account if it's a TOD. And so what we've done is we created a new letter for the TOD accounts. And what we're saying is, hey, you're so good to the charitable sector this way, you know, please make an exception for the charitable sector with these TOD accounts. And in fact, I just got an email right before we started this webinar that our new letter had worked with this particular custodian. And so we're thrilled about that. We've had 2 charities use the TOD letter, and 2 charities have been able to get the exception. And so we're very, very glad, and we're hoping that we can continue that. But we are starting to put the TOD information. Even though the RIF database started out as IRAs, we've expanded it to help nonprofits with these TOD accounts. And we're real happy to be able to do that. You might wonder what else we've been doing on a national basis. And we reached out a couple years ago to Senator Grassley, who is the chair of the very powerful Senate Finance Committee. And we told him what's been going on. We've given him some documentation. And so he assigned to me an investigator from the Senate Finance Committee. And I gave that investigator the information on which custodians were giving us trouble, and he's looking into that. And so I have given him also the information for the Financial Services Organization and our smoking gun email where they said, you know, we're not a new customer. And so I'm waiting to hear back from that. So let's hope Mr. Grassley can help us do that. Now, he's a Republican on the Senate side. And so we've also reached out on the House side to the chair of the House's Financial Services Committee, and that's Maxine Waters. And we're asking her to help too. So we think we've covered the Republicans, the Democrats, the Senate, and the House. We're just trying to get some response. We have tried to meet with Fidelity one-on-one. They did offer us a meeting, and then when we followed up to schedule that, unfortunately, they have not followed through. And so we are waiting. As we talk about Fidelity, I do have a very special letter that is just for Fidelity on our on the RIF database. And so if any of you are working with Fidelity, they have been difficult in this regard, and so they do warrant their own special letter. We're also working with ACTEC. So ACTEC is the premier organization of estate planning attorneys, and they have a segment that is the charitable side, and they have a segment in there that's the employee benefits or the IRA side. And so I'm working to get those two together. They're going to have a lot more pull, a lot more weight to Congress than necessarily the charitable sector has. And so we're going to be reaching out to them to see what, if anything, that they can do. And so the last resort is typically something that nobody actually wants to have to do, and that's litigation. And so there have been attorneys that have been doing the research for a class action, and at this point they need a lead plaintiff to kind of head that class action, not really head it, but be the lead plaintiff for that. And so if anybody on the call is interested, I can steer you to those people that are handling that, because that at the end of the day might be the only way that we can get some of these custodians to budge. Would you like to get involved? Would you write a testimonial about the experiences that your organization has had in trying to get these death claims paid? Has it taken 12 months? Has it taken 2 years? How many times have you had to go back and forth? One organization told me they were on their 5th submission of the paperwork because they were constantly getting that paperwork kicked back by the IRA custodian, because one day they used whiteout, one day somebody else signed one form and somebody else from the company signed a different form, and so these petty reasons, they kept getting it kicked back, and things were taking 1 and 2 years to get paid, which is of course ridiculous. So if any of you are interested in writing a testimonial, please let me know offline. Go ahead and write it, send it to me, or send it to, if you don't want to copy me, send it to Mr. Grassley, Charles Grassley. We have his contact information, Maxine Waters. And we're also asking people to copy their letters to Ken Blanco, B-L-A-N-C-O, who is the head of the financial services organization, the one that oversees the Patriot Act. And so we're doing our best to get their attention so that they can put out edicts to straighten the situation out and make it easy for all of us to get our claims paid quickly. What kind of resources are out there? Well, if you'd like to take action, I really suggest you contact Senator Grassley. Again, he's the chair of the Finance Committee. He's aware of this situation. He's got that investigator, Maxine Waters. She's the Democrat on the House side. But if both of them knew everything that was going on, they might do something. And so we need to keep feeding them the information, because remember the old adage, the old saying, a squeaky wheel gets the grease, and that's what we need. In the meantime, on a case-by-case basis, use the RIF letters that we have available for you. They're on the website. They're there. They're well written. Hats off to Charles Schultz for all that he has done to make those letters great. We've got the attachments there that you need. So feel free to use those letters, but avoid working with the entry people that are just answering the phone. We need to go to the top of the organization. If any of you are willing to write a testimonial, please let me know. And if you have results, if you have good results or if you have bad results, let me know so that I can keep the database updated for the rest of our fellow nonprofits across the country. So if something's gone well and we know that letter is working, if it's not going well and we need to tweak the letter, that's why, for example, Fidelity has its own letter. Let us know so that we can keep each other informed and help the industry as a whole. Now, Nathan and Jen, I know that people have been sending in questions, and so if you two want to let me know what some of those questions are, or you have your own comments you'd like to make, I'd like to stop and turn it back over to the two of you now.
Great, thank you, Johni. We do have a handful of questions, and we also have a bunch of comments. I think you might have some possible testimonials in the making right here. So I did send some over to Nathan. I'll get started with a question from Susan. She says, we are currently awaiting a distribution from an IRA. There are 10 charities that are receiving the distributions, and apparently not all 10 have opened their new accounts. So all the
Jen, we're kind of losing you there.
Have any?
I think we've lost you, Jen.
Hi, I'm sorry. Did you
You broke up.
Did you hear my question at all?
I got 10 nonprofits.
Okay.
Not all of them have applied to open up that inherited IRA. Obviously, some are pushing back, and some have done it. But I didn't actually get the question though.
So the distributions are being held up because not all 10 have opened their new accounts, and she's wondering if they have any recourse for this situation.
If the IRA custodian will let you know who those others are that need to open the account, and those 5 others, one asks for an exception, that's what I would do. If you want to email me offline and let me know which IRA custodian it is, if it's one that will make an exception or not, I think we can write some letters on your behalf. And so you might email me. I think in a later slide they're going to show my email address, but I can help you and we can get that moving.
Great, thanks,
Sure.
Johnny. Since I'm having so many internet problems, Nathan, I'm going to just send all these questions to you, and you can post them to Johnny.
Awesome. Awesome. No, first, yeah, and I've got some questions here, and I'll kind of click through these, Johnny, but thank you so much. I mean, again, truly great work. I remember when you started going down this road, and again, with Jonathan and Charles and everybody involved, it's crazy that we have to deal with this. I mean, you'd hope it'd be easier, but obviously it's not. So this is just amazing work. And I'll actually start with not a question, but a statement from our good friend, John Krause out at DU. And he says, at the risk of sounding like a paid endorser of Johni Hays, I want to say the letters work. For years, we complied with the request to open new accounts and provide our CFOs personal Social Security and contact information. And when they got a new CFO last year, took the approach that we would resist any and all requests for her to provide our information. And they used the IRA letter a few weeks ago, even with American funds, and received our distribution within a week. We also used the sample TOD letter with Morgan Stanley last week, and they are wiring our assets today. He strongly urges all nonprofits, big or small, to push back and try to use the letter as your first response, and be sure to copy Johnny and obviously Charles Grassley, Maxine Waters, et cetera, et cetera. And if you come across a new company that isn't listed on the CGP IRA resource page, reach out to Johnny, as she is happy to help. All
right. Thank you, John. Appreciate that.
So yeah, again, I'll attest. Again, we've had a lot of clients who have utilized it, and it's a great resource and much needed. So let's get to some questions. I know Nina had a question early on in the talk, and reference is this occurring with smaller IRAs that are within the dollar range that would normally indicate a payout as the only option. As far as are there issues with smaller IRAs too? I mean, it's across the board.
Yeah, it's across the board, large or small. Like I said, one worldwide nonprofit got 10 cents because that institution wouldn't tell how much it was. And I just think that's just unbelievable poor customer service, not to be able to share that. But yeah, large and small, it's happening to, they're just blindly going down the road and saying, this is our paperwork and don't ask me anything else because this is the paperwork I need. Well, we don't need somebody at that level. When we need an exception, we need to go to the top to say, look, your procedures are stupid, and you can get around them, and here's why you need to get around them, and your general counsels can make those sort of exceptions.
Yeah. Well, and I've got a question from Amy here on, she'd love to hear how others obtain death certificates, because she's had experiences when we didn't know our charity was a beneficiary and they didn't have any relationship with surviving family. And unfortunately that happens. It happens quite a lot.
But you can get a copy of a death certificate. And so if you know the county in which that person lived, then you can request a copy of the death certificate without going to the family. And so if you don't know where the person lived, then we have to do a little more due diligence there. Yeah. Does that help? If that doesn't help, let me know.
Yeah, no, and that's a good comment too. And I think, is it your next slide that has your email? I'm not sure.
Uh,
Yep, there we go. We'll
there
leave
we
that
go.
up here. Jen can kind of close on that. That way everybody has access to your email too. Tom brings up a comment here. Wells Fargo advisors say that they do not follow IRA distribution rules of Wells Fargo Bank. Have you heard about this, as far as Wells Fargo advisors are concerned?
That something is, there are different processes between the Wells Fargo advisors versus the Wells Fargo Bank.
That's what it sounds like.
No, but I'd love to hear more so that we can update the database and bifurcate that into two, if it's Wells Fargo advisors or Wells Fargo Bank. So yeah, please let me know. I'm very grateful for information from you all so that we can make that database even more accurate and better all the time. Thank you.
Yep. Tom, be sure to reach out to Johnny. Vicki had a question. You know, obviously the discussion today is around IRA administrators and some of the challenges. She was curious, do these methods also apply, and Johnny, with your work in the past, to annuities? And we have to open new accounts to transfer annuity funds over to us as the beneficiary once donor dies. And those forms generally require medallion signature guarantees, which are near impossible to obtain. So Vicki's curious. I know you've done a lot of work in the annuity side of the world.
Yeah, and so your annuity can be funded with IRA dollars or, you know, a SEP, or could be an annuity under a qualified plan. So those annuities are going to follow those rules that won't need the medallion signature. But if the annuity, on the other hand, is filled with after-tax dollars, right, then those are what we call they might call it a TOD account, they might call it a beneficiary, and it depends on the custodian. So we just found out that Morgan Stanley's IRAs are smooth and easy, but then if it's a Morgan Stanley after-tax account, they do something different. And that makes it so hard for us as an institution, because if they've got different pockets of business, then are they all doing it differently? And that's tremendously difficult for us. So if the annuity is in the IRA division, it might get paid this way. If the annuity has non-qualified money, it might be a different division of the company with a different leader. And hence we have to go to the very top of the food chain there to say, look, you know, you guys are doing this 10 different ways, and it's not helpful.
Well, that's the importance of the work that you talked about. I mean, again, trying to get some consistency is critical, and that's easier said than done sometimes. A couple more questions here. I know we've got, I guess, about 10 minutes left. Bob had he actually had a great question around COVID virus. Is the COVID virus causing delays, or is this just another excuse why we aren't getting our money yet? Have you seen any delays with the COVID virus?
I have not seen any COVID-related delay. This Patriot Act thing started about 5 or 6 years ago. And again, in my opinion, it's an asset conservation technique by the IRA custodians, because they make more money the longer they have your money on their books. I'm not saying there's anything wrong with that. That's how they do things. But when it comes to absurdly interpreting Patriot Act terrorism rules to say that the Smithsonian, you know, we've got to go through this process to make sure that the Smithsonian is not a terrorist when they're actually a partly government agency, that's ridiculous. So no, I haven't seen COVID used as an excuse just yet.
Just yet. Good to hear. Allison has a question going around back to the setting up of an inherited IRA. In fact, if they had set up an inherited IRA before, while trying to get their distribution, should they go back and close the inherited IRA after they receive the funds?
Well, once you've set up the inherited IRA, you've already had to do the bad stuff. So you've already had to give your Social Security number, so that your personal information, the financial statements, all that kind of stuff, you've already done that. So I wouldn't say unwind that. I would just say, just try to liquidate that inherited IRA as fast as you can. And then the next time, know that if you want to push back as an organization, then do it the next time.
Good stuff.
That's a great question. Thank you for that.
Yeah, and Victoria has a question around liquidation here is, they want to charge a fee to liquidate the funds. Is this acceptable? If so, what is a fair fee?
Oh my goodness.
Right?
So they want you to pay money to get your own money back. Is that right? When you've lost somebody near and dear to your organization. I really can't comment on what would be an appropriate fee. Anything in the zero range, I think, would be appropriate. Other than that, I think, oh my goodness, are you kidding me?
Isn't that crazy?
Mm-hmm.
Oh. Deborah's got a question here. Should we also make a case for our local and state representatives in the House and Senate? I know you gave the, starting from the top and working with the folks you mentioned with Senator Grassley and Maxine. Is there anything on a local and state level that folks can do or should be looking at?
Well, that's a great question. And, it's hard to get the attention of the Fidelities and the Vanguards and the Schwabs and the RBCs on a state level. The federal government agency that oversees the compliance of the Patriot Act is a federal government agency. And so that's why we're looking at it from the federal level, because we think there would be, we have a better chance of getting something solved and improved if we do it on the federal level. Maybe if one of those organizations was home-based in your state, that might be a way to go to your state. And by the way, I have tried in Iowa to, just bring this up, and it hasn't gotten me anywhere so far, but if you want to try it, I'd say go ahead. But we're really focused on the federal level.
Yeah, no, it's a good point. I know we've got still quite a few questions. We're going to probably likely run out of time, so I'll pick a couple of these. If you don't get your question asked, again, do feel free to follow up. Obviously, Johnny's always helpful in this and willing to help. There's so much need with this, but we do have some around paperwork and questions and just some requests people are getting. Cynthia has a question around where she's received paperwork that is asking for CEO and board member to sign their corporate resolution form, which is problematic, especially since most of us are remote. Have you heard of such a request? They have authorized signers on a resolution, which we include with the paperwork. They have authorized signers, yeah.
Yeah, I have heard others that are pushing back on having the corporate resolution have to be on the IRA custodian's paper instead of your own corporate resolution. And I would push back on that. I would just say, for goodness sakes, this is dumb. We're all getting to the same procedure. But remember, when you're talking to somebody at that entry level, that clerk level, all they know is, here's my checklist. I need this, this, and this. And I can't make an exception, and I can't look outside my blinders. So sometimes when you're working with the corporate counsel, you can get those kind of things waived better.
Yeah. Well, and Sarah here has a question around their auditors. Auditors often ask for financial statements, which custodians say they're unable to share with us. Sometimes the only contact they have is the custodian. We don't necessarily have contact with the estate executor or any attorney or advisor. Do you have any advice on how to obtain financial statements for descendant IRAs?
So whose financial statement are we looking for?
Sarah's mentioning that their auditors often ask for financial statements and the custodians say they're unable to share that with them. The only contact they have is the custodian.
Okay, and the charity's auditor is asking for the financial statement of the donor?
That's what I'm trying to.
Yeah, email me that one, please, and I'll respond to you directly on an email on your question. Okay, thank you.
That'd be good. Nancy has a great thing, and I think this is something I know we try to work even from a marketing side. But it seems like the issue of IRA custodians not notifying charities if they're a beneficiary of a descendant's account could be an important message for why donors might want to disclose an IRA gift to a charity. Any thoughts on how, if this is something charities should consider, and if so, what messaging might be appropriate?
That's a great idea. And, if that's happened to you before, or, the one particular custodian that has it right on their beneficiary form, we're never going to know. And so I think that is a good message. Please let us know, and here's why we need to know. Here's why it makes sense. If you don't let us know, we may never get your legacy gift and be able to use it to help our mission. And unfortunately, I think that's something that we just have to say, oh, and by the way, please let us know, and allay their fears on whether or not you're going to, they think you're going to do something more now with them, but just say, look, here's how it is. They're not going to tell us. And so if you let us know, that's the only way we're going to be pinged to be able to help use your gift to support the things that you care about with our organization. So absolutely.
Yeah, no, and I agree. I know we try to with our clients when they're promoting gifts from IRAs, because we know, a lot of people keep these decisions close to the vest. Please let us know, the IRA administrator, if you've done something in your IRA, they will not likely tell us. And so again, everybody as a donor, you want to be assured that your dollars are going to go to where you want them to go. And so, it's wherever you can, one-on-one, it's a lot easier, but if you can work that messaging in, it's really important too.
Yeah. And like you said, Nathan, one-on-one is probably the best time to have that conversation, but you don't always know if people are going to be off doing it themselves and not letting you know. So yeah, great point.
Well, we're coming to the end here. We've got one more just from Catherine. I love this. I think this is a great way to end. And then again, there's some others, so hopefully people will reach out to you directly, Johni. But what about starting a social media campaign to call out these financial institutions on their policies? Do you know if this has been done at all? The power of social media.
Let's see. Do I know if that's been done? No. One lawyer wrote an op-ed in the Washington, I want to say, Examiner. We got zero feedback from that. One day I did put on one of those custodians' emails, would you help charities, blah, blah, blah. And I didn't get anything back on that, but it can't hurt, right?
Right. Now, we all know, good, bad, or indifferent, the power of social media. I mean, maybe there is something there to get some of these things moving quicker. But again, I'll close, and I know Jen with her internet issues, I'll help close out here today. Thank you so much for sharing this information today. I know you've shared this a couple different times over the years. It's just so important, and obviously. I think you're going to get some testimonials, it sounds like, from some folks, and definitely if others have questions, we shared the email addresses. Johni is just a terrific asset to the industry, and we'll be happy to help out whatever way she can. As Jen has put up on the screen here, we will hope to have this recording packaged up and bundled for everybody here in the next couple days. When it's available, we will send that out to everybody, so you have access to that, but it will be also available on stelter.com/webinars. So thank you, Jen, putting it to the thank you screen. We want to thank Johni again, and the great folks at Thompson Associates for the time today and the great insights. And hope everybody has a great rest of, I guess 2020 is going to come to an end eventually here. So I'm glad we were able to close it with Johni.
Thank you, Nathan and Jen and the whole Stelter team. Thank you so much.
Thanks, Johni. Take care, everybody.